To our next case, number 12-4664, United States versus Randall McGee. Mr. Byrne, we'll be glad to hear from you, sir.
Morning, Your Honors. May it please the Court. My name is Jonathan Byrne. I'm here on behalf of Randall McGee. A commentator once wrote that very few drivers can traverse any appreciable distance without violating some traffic regulation. That was true when it was written in 1969, and it's doubly true today after 4.5 decades of further regulation. Even more important is that in the 44 years since that was written, courts have repeatedly expanded a police officer's ability to engage in criminal investigation of persons subject to a traffic stop that are not related to the reason that the stop was made. And therefore, it's incumbent on the courts to ensure that when a police officer says, I stopped this vehicle for reason X, that there is some factual basis to believe that reason X is correct. On the record before us in this case today, the reason given for pulling over the car in which Mr. McGee was a passenger doesn't have any basis in the facts that were developed during the second suppression hearing below.
But you agree that to support your position ultimately, then this court would have to overturn Judge Johnson's credibility determination?
Yes, Your Honor.
Okay.
And I recognize that's generally a tough row to hoe in this court, but this is one of those rare situations where the totality of the record undermines Judge Johnston's conclusion, because his conclusion that Officer Halstead's testimony went unimpeached is simply not correct. We have independent, third-party, uncontradicted evidence that indicates that the third brake light, which was the only basis for the traffic stop, it was functional on the vehicle when it was found after the traffic stop, that service records of the vehicle indicate it was never repaired, there were never any complaints made to the rental agency that owned the vehicle. There's simply no reason to believe that it happened not to work on a single occasion that serendipitously provided the basis for a traffic stop that led to the seizure of narcotics. And the fact that the basis for denying the suppression motion is a determination of the officer's credibility doesn't insulate that determination from review from this court. And other courts have recognized that in similar cases, situations involving a brake light that was allegedly defective or taillights that were defective, that when the vehicle is found later, everything is in order and there's no indication that there was a problem with the vehicle in the interim, that probable cause doesn't exist to support those stops. If there aren't any further questions on the traffic stop issue, I'll move on to the sentencing issues. The main sentencing issue in this case, I think, is the district court's determination that the sentence it imposed was imposed in order to, quote, send a message, unquote, back to Detroit, which is where Mr. McGee is from, to parties unnamed in a manner unknown. The basis for this, or part of the reason for imposing this sentence, was an ex parte, off-the-record conversation between the district court judge and the United States attorney. The district court doesn't explain how this sentence is going to send any kind of message. There's no indication it made the news in Detroit. It's a garden variety criminal case in Charleston, West Virginia. There's no reason for it to make the news in Detroit. And the district court didn't give any reason why a lesser sentence would not send the same message, why a 55-month sentence was necessary to do that.
But didn't the court, in tying into Detroit, because at first I was concerned about this too, but then in looking at 331 of the JA, the court says, I've considered it an aggravating factor when drugs were being brought in from out of state because, essentially, he starts a new sentence, that indicates a higher level in the distribution system than somebody simply dealing on the streets. And so isn't that a reason other than just bias against a certain group of people?
It would be if there was more evidence in the record that Mr. McGee actually was doing any selling of the drugs in the Southern District of West Virginia. All the evidence indicates that he and the person who was driving the car he was in were passing through. And in addition, that still becomes you're from Detroit, you're getting hit harder. Even though...
You're a higher level dealer, is how I read that.
Well, I think it makes an assumption that's not necessarily supported, that someone's a higher level dealer just because they come from one area to another because the market, in essence, dictates that they're going to make more money selling in one area versus another.
Well, there was more to the facts than just that comment. He had a ticket, a bus ticket in somebody else's name. You had suspicious text messages. You had unexplained large amount of cash and conflicting stories about his trip. I mean, all those factors were considered by the judge.
But that was, Your Honor, those were all factors that relate to the relevant conduct issue. And of course, our position is that the district court erred in considering that as relevant conduct.
But it could go to Judge Keenan's comment about it's a higher up thing. That's evidence that something's going on.
Well, with due respect, Your Honor, it's evidence of something, but it's not necessarily evidence of the sale of drugs. There was no evidence at the time of that initial stop, the stop at the bus station, that Mr. McGee had been selling drugs. There were no controlled buys. There was no CI who said this person has been selling drugs or has been bringing drugs for other people to sell.
What about the text message? Are they moving? How many do you have left? The total should be $6,075.
But, Your Honor,
Isn't that circumstantial evidence of drug transactions?
if you read it looking for circumstantial evidence of drug transaction, it is, but
I meant in the
it assumes
context.
assumes the conclusion.
Well, I meant in the context, though, of somebody being instructed to buy a ticket in a different name. You know, that's unusual, isn't it?
I couldn't say whether it's unusual or not, Your Honor. I don't have a lot of experience in that area. But it's worth noting that after the officers seized Mr. McGee and they had this money that they think is drug proceeds, and they seized the drug proceeds, they let him go. They didn't arrest him. They didn't hold him seeking any sort of additional information to charge him either in state court or federal court. So there's some reason to think that there's not enough evidence there to construe that as the district court construed that evidence.
Now, he was carrying, what, 400 pills at the time of the traffic stop?
I think that's correct, Your Honor.
Okay. And at the relevant conduct time, he gave the, what exact explanation did he give regarding the $5,800?
I remember.
Could you go over that for us?
If I remember correctly,
He couldn't explain
Your Honor,
it, right?
He did. He gave some conflicting stories.
He traveled to see the
about,
mother of his child, and
Yes.
but he really couldn't explain where the $5,800 came from.
And I believe he also suggested they were gambling proceeds.
Okay.
Which, for those who aren't from the Charleston area, there is a casino and racetrack just outside of town. So that's not a far-fetched explanation. But there are many reasons why someone could have that amount of cash on them. And again, it depends on if you're looking through it through the lens of we think he was dealing drugs, therefore these things confirm that suspicion, or we don't have any other evidence that he was dealing. What does this tell us about him?
Okay, now our lens, and I think it is important for us to know what was the trial court's evidentiary burden or evidentiary lens, and it was a preponderance, wasn't it, on the relevant?
On relevant conduct, yes, Your Honor.
Okay.
And the district court admitted in making the ruling that it's a close call, and so Judge Johnson recognized that this was not an easy case on that issue. If there are no other questions, I'll reserve the balance of my time.
Thank you very much.
As to the, when it comes to the stop, the United States, or is that there, under the clear error standard, that the district court did not err when it found that Officer Halstead was credible in its finding. That's a standard that is left to the district court because the district court is in the best position to judge to observe the witnesses and determine its credibility. The district court had that opportunity in this case on 2 occasions when Officer Halstead testified during 2 pretrial motions hearings. During those hearings, Judge Johnston found that Officer Halstead was a credible witness, that he was frank, that he was earnest, and that his recollection of the events was unwavering. Judge Johnston further found that Officer Halstead was unfailing during cross-examination and that he was unwavering in his testimony that the center brake light did not work during the day that he stopped the Avenger in this case. Judge Johnston further found that Officer Halstead's testimony was the only direct evidence as to the condition of the Avenger's center brake light on July 26th of 2011. And therefore, Judge Johnston found that the officer had probable cause to stop the Avenger that day. This court has to view the evidence in the light most favorable to the government when reviewing the district court decision, and based on that standard, the United States believes that the judge's ruling should be affirmed. As to the sentencing, the within guideline sentence is presumptively reasonable. The defendant's sentence is both procedurally and substantively reasonable.
Can a federal judge impose a greater sentence on a defendant because he or she is from out of state?
No, not just because he or she is out of state. I believe that's a factor that the court can consider when it's looking at.
Why is your answer no? Why can't
I don't think that it could just not.
Apart from it just smells bad, I think we all agree to that. But what's at the bottom of your answer?
I don't believe that that's not what the district court did in this case.
I didn't suggest that. I'm asking you, can a judge routinely or habitually say drug dealers who come into this jurisdiction from outside the jurisdiction are going to be treated more harshly than drug dealers who from around here?
I think that that's a proper consideration for the district court to consider.
How is that different? What did I say that changed the prior hypothetical?
Well, I think that the prior was that can he consider out of state? What the district court did in this case was say this area, Southern District of West Virginia, has a problem with drug dealers coming from Detroit to this area to target Southern District of West Virginia as a distribution place. It's well within the district court's discretion to look at what area, what problem is facing, what law enforcement problem is facing the Southern District of West Virginia. And what the district court did was recognize that in the Southern District of West Virginia, there's a problem with Detroit drug dealers traveling to the Charleston, West Virginia and surrounding areas to distribute drugs. That has become a significant
So if a drug dealer comes from Newark, New Jersey to the Southern District, it's okay to give that drug dealer a lesser sentence? Because that drug dealer is not from Detroit?
I think that what the district court said was, I look at drug dealers who travel, in particularly, as higher in the drug distribution range.
So if the defendant had been from Los Angeles, you think the judge would have said the same thing? I'm going to send a message to the people in Los Angeles County.
I think what the judge said was, first and foremost, I look at drug dealers who travel as higher in the drug distribution range. I don't see you as a street-level drug dealer. You have traveled with drugs for distribution purposes. He considered that an aggravating factor because that indicates that you're not just a street-level drug dealer, you're traveling interstate to distribute drugs. It didn't matter where that person came from.
I see.
And then he said, in particular, we have another problem on top of that, which is we have an influx of drug dealers from Detroit. Because
I'm not following that. I thought you...
The judge considered 2 different factors. He considered the fact that this defendant one traveled interstate to distribute
From
drugs.
Detroit.
Well, first he considered, if you look at the JA at 331, the judge said first, I find the fact that you traveled interstate, I consider you farther
Oh, but
up
the
in
judge had the PSR. And the PSR is just filled with information about Mr. McGee coming from Detroit. He's got a record in Michigan. He clearly is from Detroit. That wasn't, judge didn't just stumble on that. Judge
Right.
knew that before he took the bench.
But what the judge said was that the defendant came from out of state and brought pills with him.
Well, he said he came from Detroit.
Correct. Yes, he did later. But the first time that the judge addressed the fact that he came from out of state, he just said, you came from out of state, which I find to be an aggravating factor because it indicates a higher level in the distribution system. You're not just a street-level drug dealer. And
So a West Virginia native who manages to get hold of 600 oxycodone pills locally, and actually I've had that case, right? The Bell case. Well, I guess that was Western District of Virginia. But oxycodone aren't just sold in Detroit. Sold everywhere, right?
that's correct, Your Honor.
And if you're clever enough and you can marshal the resources, you can get 600 pills in Charleston or Huntington or Detroit or Pontiac, Michigan or Baltimore or Richmond, anywhere. They'll sell them to you.
That is correct.
And indeed, doctors will give you a prescription for them. Look, I don't want to spend any more time on this unless you want to, but as Judge Keenan said, on the face of it, it makes me nervous to see a district judge talking about Detroit
Well,
in this way, people from Detroit.
I think what the district judge said was that when he addressed the factors, he first said, one, you possess drugs for distribution. And
Which was the offense. Yeah, it's
which
the
was
offense of conviction.
You possess
Yeah.
pills and you possess cash at the bus station 2 weeks previous to that, which the judge found was relevant conduct, which contributed to one of the most serious law enforcement problems in the Southern District of West Virginia that the court saw on almost a day-to-day basis. And then the court said, and I find that you traveled from out of state and brought the pills with you, which I find to be an aggravating factor because it indicates a higher level in the distribution system. And that's at JA 331. At that point, the district court didn't say you came from Detroit. He just said you came from out of state and brought them. You're not a street-level drug dealer. You're traveling to do it. And then he says,
What about the guy who was driving the car?
Mr. Moore,
Is he a high-level drug dealer?
Mr. Moore,
Yeah.
the court specifically said, I found that, and he further indicates during later on in the JA at sentencing that the defendant had paid that individual
Right.
to bring him to the
Right,
Oak Hill,
so-
West Virginia area.
So is he a high-level drug dealer, aiding and abetting a high-level drug dealer? Does that make you a high-level drug dealer?
Well, my response to you would be no. He is actually,
So two guys coming from Detroit, one's got a car being paid to transport the other one who's got the pills. I mean,
you have to know what the driver knew about Mr. McGee's activity before you could be able to charge him with aiding and abetting.
he didn't get charged?
He did not get charged.
He didn't get charged.
So to the extent
Did he have an immunity agreement or?
he
Because
was,
he did testify.
no, he
I
did
mean,
not.
he didn't testify, but he
He
made
gave
a
a
statement.
statement to the
Yeah.
officers. And whether or not he knew what he was driving Mr. McGee for, there was no evidence of that, other than he gave a statement to the officers that he was paid by Mr. Moore to bring him to the Oak Hill, West Virginia area. And then after the district court made the reference to the fact that the defendant traveled from out of state, which he found to be aggravating, he then says the need for deterrence from individuals like the defendant traveling from out of state, and particularly Detroit. For those reasons, the court found those three things specifically to be aggravating factors. Therefore, the court declined to vary. And then the court went on to address the defendant's criminal history and the fact that he had had prior sentences that had not deterred him from criminal activity, and therefore the defendant needed a stiffer penalty, and the seriousness of the offense and the fact that the offense involved opiate pills, which the court found created serious addiction problems and were very dangerous drugs, causing problems in the community and ruining lives, and were very difficult addictions to break, which called for stronger sentences, which the court had been imposing regularly in pill cases. And considering all those matters were why the court imposed the sentence that it imposed. And it didn't give greater deference to the fact that the defendant was from Detroit. It considered all of those factors when it imposed its sentence of 55 months. And it adequately explained its sentence, and therefore the United States Police that the sentence imposed by the district court is reasonable. If the court doesn't have any more questions.
Thank you very much, Ms. Coleman.
Your Honor, I want to return first briefly to the Fourth Amendment issue, because through its brief and now through its argument here today, the government simply ignores the second suppression hearing. They've never discussed the facts that were developed in that hearing. They've never taken on the cases we cited that showed that in similar cases, the courts have said that's a Fourth Amendment violation if a stop's made on that basis. And the fact that they ignore it doesn't mean they don't exist. The facts there don't exist, and those cases don't exist. And I'd urge you to take that into consideration when you're deciding that issue.
I guess I'm not sure how the law helps you. The law is pretty clear, as one of my colleagues said to you in your opening argument. It's a credibility call.
But it is, Your Honor, but the Supreme Court's recognized that credibility is more than demeanor.
Well, of course. But I mean, how can we second guess the judge?
Easily, because
Easily?
Well, not easily. I'm sorry, that was flippant. But because we have independent, third-party, uncontradicted evidence. The judge had to invent theories as to explain away this evidence. Theories, by the way, that the government hasn't adopted. One of them is that somehow Enterprise misplaced a record, didn't pay for...
Have you ever had a light bulb? You're sitting in your nice, comfortable chair. Maybe you have the TV on, watching Jon Stewart or somebody, and you're sitting there and you're reading a brief or you're reading, you know, The Economist, and the light bulb goes like this. And you kind of go, that's weird. That ever happened to you?
I've had things like that happen, yes, Your Honor. But there's nothing in this...
Do you think it's beyond the realm of the physically possible that a drug dealer could actually be so unlucky as to be driving through West Virginia and have a tail light go out at that moment when a police officer is watching him, watching the vehicle in which he's traveling? I mean, it's not like it's physically impossible.
Your Honor,
I have machines that fix themselves all the time. It's amazing. In fact, I had a visitor in Chambers this week whose iPad, she's had the iPad for years, and all of a sudden the iPad said, unavailable for the next 17 minutes. She had never heard of such a thing. I've never heard of such a thing. And sure enough, in 17 minutes, the iPad was back online.
Your Honor, anything's possible.
Not anything, but a lot of things.
But there's nothing in the record to explain how that would have happened in this particular vehicle.
Well, how do you explain the blinking light bulb?
I don't know, but I'm not pulling someone over. I'm not restricting their liberty. I'm not initiating a criminal investigation
and so
based on that.
The judge has to weigh the contrary evidence with knowledge that things happen, mechanical things happen in unexplainable ways, and he's got this law enforcement officer sitting there who may be committing perjury. Nobody says they don't. In fact, we know full well they do. But the question before Judge Johnson was, is this officer today in front of me, in this case, sitting there committing perjury? And the judge, when you went back, the judge reconvened the hearing. Mm-hmm. So the judge didn't say, look, I've made my decision, you know, I don't want to hear anymore. The judge was willing to really look at what you present.
That is true. He heard the evidence.
Yeah.
I would just say two things to that. One, there are other cases where the same situation has happened, and courts have said there is no probable cause to base a stop on this. And the second is, if
And appellate courts didn't, I mean, to the extent the government,
one was a district court case, it was not appealed. The other was a Seventh Circuit case that was actually a finding of liability and refusing to find immunity for officers in a 1983 suit. Those are the two cases that are in our brief. The other is, if the court affirms on this basis and this credibility determination, and we know now from research into how the mind works, how the brain works and everything, that the certainty of someone who is testifying is a poor predictor of their accuracy. But if the court affirms this situation, it's carte blanche for officers to pull over someone that they suspect might be up to no good but can't prove it.
I think that's an overstatement, but I don't
two-
fault you for that.
Two things very briefly on the sentencing issue. One, the Southern District of West Virginia has no pharmaceutical industry. Every pill that's sold in the Southern District of West Virginia comes from outside the state. And secondly, there was no evidence that the cash that Mr. McGee had at the time he was stopped at the bus station, that it came from West Virginia. So my time is up. Thank you, Your Honors.
Thank you very much, counsel. As always, we appreciate your presentation. Need a break? Okay, we'll come down to Greek Council and take a brief recess.
This honorable court will take a brief recess.
Oh, I'm already over.